Now, the smartest guy with a bow tie in Chattanooga, Tennessee, David Tulis.
The reason reform is difficult, I would say almost impossible, is that people are accustomed to the way that they've done things, of course, which is what custom means. Custom is, we've done it this way before. As far as I can remember, the judges before me did it this way, the prosecutors before Neal Pinkston did it that way, his way, and we can't really change, we really can't change direction, even though the law demands it. And even though there are admissions that the law requires it, we just can't change the way we do things in Hamilton County's courts. There are 3 criminal judges in Hamilton County: Barry Steelman, Tom Greenholz, and Don Poole, and we are incapable because of custom, because of tradition, and the difficulties of enforcing the law. We just can't really get around to enforcing the law. And the law that I'm talking about is, if enforced, one that would bring an end to the financial crisis in the county, one that would bring an end to jail overcrowding, one that would bring relief to the common and poor people whose mugshots you see at Chattanooga Time-Free Press, at the Right to Know page, or on Chattanooga.com, the jail bookings report for Hamilton County. I'm looking at the one put out by John Wilson, I believe, yesterday, that's right. And there you see first the list, and the names, of course, are all capital letters. They're styled, for example, Christopher David Aquina, who's the first one, it's styled all capital letters. Now that is to say that the party being addressed by this is his avatar, his corporate and legal person, not the flesh and blood man. However, the flesh and blood man is being made to account for the sins, if you will, in commerce under the Uniform Commercial Code of this man. Now, these sins are grievous, okay? They are grievous: muffler law violation, driving on revoked, suspended, or canceled license, possession of controlled substance. These are not just these are crimes, allegedly, right? Now, if we have enforcement of the statute that requires a proof of intent, which is to say Tennessee Code annotated 3911-201, if we have these 3 judges remind themselves of this law, actually take the book out and read it, not go to Westlaw and read it there just for reminder's sake, for old time's sake, college day sake, when they read some of these laws for the first time, and absorb them and try to understand what they meant, but review them in paper, not on the screen, but on paper, in the actual volume of the Tennessee Code annotated, I think published by Mitchie. Look at the printed page, the page that doesn't move, right? The page that's always there, even though the heavy green bound volume is closed and is put back on the shelf and not forgotten, of course. Read the printed version, the one that doesn't change, the one that doesn't flicker away, right? The one that can't be redacted on the slide by the American, the American Law Commission people who are trying to make us all subject into commerce. Read that law and see what it says. It's about intent. It's about in Latin, mens rea, the doctrine of mens rea, culpable mind. Every criminal charge that is made by Neal Pinkston in this county, and in perhaps by the DA in your county, if you are not from Chattanooga and Hamilton County, the law requires that on today, Cash Friday, right? Today, on Cash Friday, and every other day, even on Saturday, even on Sunday, the Lord's Day, even on those days, if there is a criminal charge made, the officer has to know that there has to be intent. The prosecutor who takes up the case has to know that there has to be proof of intent, and that now the prosecutor, having been given the accusation by the fraternal order of finger pointers, will have to argue before the jury that this man intended to have a muffler law violation. In fact, that has to be proven. That has to be proven. And we can have reform in the courts. We can have reform in the very burdensome, tax burdensome system of jails and transportation systems that bring inmates to and from the jail, to and from Silverdale, to the courts, back and forth, at great expense, even some held probably in remote places. All these expensive systems with their manpower, their payrolls, their insurance payments for people who are employed by the county and by the city, all of those can be cut. All of that can be cut, right? Those good people can find valuable work in the private sector, Lord willing, if this one statute is honored. If Judge Poole, if Judge Steelman, if Judge Greenholz, Tom Greenholz, the newest one on the bench in the county, would just look at the statute and would say, you know, we need to take responsibility of the growing crisis in the judicial system in our country, the grinding of the poor, the grinding of the black man, right? The grinding down of the common people, which is what our job is really all about. It's not really about justice anymore, despite the high words we say about our callings, our professions, our careers as lawyers, right? Remember, judges are just lawyers. That's all they are. They're just lawyers who got elected. That's all it is. They're just lawyers who got elected. And now they have a patina of authority and a patina of honor. Let's hope that it's real honor. Let's hope that each of those judges in this county who made an oath before God to uphold the Constitution and uphold the law and seek justice and bring justice, that they will say, you know, this statute in the Tennessee Code really is about justice. It really is, rather than to view it simply as an impossible burden, a requirement that's impossible to meet in the case of Christopher David Aquina, or the next one on the list, Kenneth Lambert Baker of Orangewood Avenue in Chattanooga. He's 54 years old. And guess what Kenneth Lambert Baker is being charged with? Failure to appear. Now, failure to appear is a crime. Oh, it's a crime. Okay, now let's ask this question: how will Mr. Pinkston and his cohorts in the finger pointers office, how will they, these men and women who work there, argue intent? Well, they don't have to. They really don't have to. And why is that? Because the judge that hears that case, all pro forma, all rapidly, of course, all just in machine process. We process people like we process carcasses in an abattoir. We don't have to worry about intent. We don't have to argue that Kenneth Baker intended to violate the statute on appearances when called to show up for a court hearing, right? We don't have to prove that. Well, maybe Kenneth Lambert Baker of 1118 Orangewood Avenue in the 37404 zip code, 854, couldn't make it. He just couldn't make the court hearing. Maybe he didn't have money for a bus ticket. Maybe he was having a relapse of some medical problem. Maybe he was having a mental crisis. Maybe his estranged son was in town, and Kenneth Lambert Baker just forgot. He just forgot, even though it was written on his calendar. He had a sticky note on his freezer in his ramshackle kitchen. I'm just imagining here. And it said to go to the court on that date. He didn't make it. Well, now he's charged with failure to appear. How is it that Neal Pinkston is going to prosecute this man? Well, he's not. You know, that's what's so funny about our court system in Hamilton County. No one's prosecuted. Everyone gets charged, but no one gets prosecuted. Why is that? Well, the poor people. There's so many of these people who are they're just indigent. They're so poor they can't even afford their own attorney. So you have another arm of the state, and that's the public defender's office, that makes it convenient for them to escape. And the escape is the plea bargain. Well, look, Ken, just you got two charges of failure to appear. Why don't you plead guilty to one, and we'll ignore the other one and call it even, right? And the time served, well, you've been here, let's say, 2 months. Well, we'll just call that's payment. You made your payment now to society, and you could go. Well, that's how. And so here we have another blot on a man's record. Another blot, failure to appear, guilty, failure to appear. And how's that going to look on his job application next time he's looking for work? How's that going to look? The whole system is operating to help this man to just get into the system. It's almost as if the system that Barry Steelman and Tom Greenholz and Don Poole accept is one that gets as many people in as we can. Just get as many in as we can. That's what it looks like. A blind chewing maw, a spinning wheel, like a turnstile in a subway, except this wheel is not up and down, it's left and right, and it's continually spinning. And if anybody walks near enough to that prong, those prongs, as they come scooping out across the sidewalk, they're sucked in, and they're effectively ruined. How you my listener, you're this upper crust kind of guy, right? You're a hind listener on the David Tulis show here at 92.7, 95.3 HD4. You've never had to deal with that. You're above all that. In fact, you've got $3,000 in a checking account in your Schwab account where you have some of your savings. You could easily write a check to have someone represent you, or you could easily write a check to pay the bond. Not a problem. You can pay the bond directly without having to go through a bondsman and pay his fee, which is 10%. You can do that. And so you don't really worry about what happens to common people. But I'm asking you, is that right? Should we not care about the common, the poor, and the ignorant, and the black, who are all of whom are wonderfully overrepresented in the court system? Many of them on charges that are commercial in nature. These are commercial government charges, as perhaps we can, as we scroll down this list, look at violation of probation. Well, did someone violate probation because they intended to? Did they intend to violate the statute on probation? Did they have the culpable mind? Did they have the culpable mental state? Did they act intentionally, knowingly, recklessly, or with criminal negligence, as it says in Title 39, 11-301? And that is the requirement. I mentioned that statute as a basis of reform. Okay, we can have reform in Helena County. We can end the abuse of the court system, of the common people, of the black people. It can end today. It can end now, if these judges will simply ask, what, Mr. Pinkston, are you going to allege and aver and try to prove is the culpable mental state? Well, the reason the judges can't get to this question is because the whole system is rigged to plea bargaining. The judges don't see a lot of these cases except in passing. There's the list, and they just check them off. They don't have to deal with cases. They don't, and no one has to try cases. Why do people not try cases? Why does the system not try cases? Because everybody is afraid, and everybody's already half ruined by the economy, by the lack of money in the economy, the lack of savings, the tenuous financial system, reality of many people's lives. And many of them, probably 40%, 30%, have mental problems. These whose mugshots you can see at Chattanooga.com, they are at wit's end. And so they can't even imagine going to trial. They just can't imagine it. And because the PD is there saying, look, why don't we just make this go away? Why don't we just say, let's see if we can work out a deal. Right? It sounds so positive. Let's work a deal out. Driving on revoke. Here we have Joshua Andrew Eaton of 1842 North Prairie Circle. He's 28 years old. The arresting agency, Hamilton County. So he violated the commercial driving statute. And the state, because the state wants you to believe that you can't travel on the public right of way, the people's roads freely under a constitutional protection. Now, that there is no constitutional property right in free movement. No, you've got to be a licensee. You've got to enter into commerce voluntarily by making application under Title 55 under the driver's license statute, becoming a licensee, and thereby declaring yourself involved in the commercial for-profit activity subject to regulation of carrying for fee or fare people or goods for hire. That's what everybody with the license is able to do, right? If you have a license, that's what you've applied to do, to be able to carry and transport people and goods for hire. Joshua Andrew Eaton apparently was involved in that, but his had been revoked, and his had been suspended, or his had been canceled, and he also did not have insurance. A lot of poor people don't have insurance. They have to afford their meds, or they have to pay insurance. They're and get some shoes for the kids, right? That's the kind of thing that we have often bedeviling common people whose glowering and sad faces you can see in the press, and of course in the Just Busted newspaper when you go and get your gas. Just look at the front page, how they select the most interesting, the prettiest girls, the most interesting faces are out there on the front. And you just got to get that publication to see who has been arrested. Of course, there's a little footnote that says down, I think probably on the first page, that just because you're here doesn't mean you're guilty. There is a presumption of innocence. But that, of course, is just That's just put there pro forma. And we all know that if you've been arrested, you are guilty. There's a presumption in the whole system, throughout the system, that if you've been arrested, you no doubt are a bad person. You're a criminal. You are wicked. What about Darius LeBron Johnson of 317 West 34th Street, Chattanooga? He's 26 years old, failure to appear. And he also had possession of a firearm with intent to go armed. That statute is unconstitutionally vague and void. It is simply, it's an anti-black racist provision in the law that was written by the white democratic establishment after the war to prevent Southern independence, to keep black people completely vulnerable to abuse. Keep black people vulnerable to abuse. They can't even have a club. You can't even have a club. You can't have a knife. So we have this arbitrary law that is effectively a total ban in Tennessee, a total ban in Tennessee on self-protection. But there are exceptions, and that's the whole system is based on the exceptions or defenses. In other words, you're presumed guilty in this unconstitutionally vague law, but there are exceptions. And one defense to carrying a weapon is that you've got a license to do it, right? It's a crime to have any kind of weapon. It's a crime. But you can have a license to commit that crime. You can commit that crime if that gun is in your car, right? That's the newest change in the statute. That you can carry, not carry, but you can have a gun in your car. Here we have another one. J.B. Jones of 17 North Larchmont Street. He's 68 years old, and he had a handgun while under the influence. He had possession of controlled substance, driving left of center lane, leaving the scene of an accident. Implied consent law, open container law, and financial responsibility. Now, how is Neal Pinkston going to prosecute that case? Under the requirements of 3911-301. Well, the judge is not going to require him to prove intent. The judge is just going to let it go. The defense attorney, especially if it's a state public defender, isn't going to have time to get into figuring out what the defense is on the intent. And if you're the PD, the main thing is just to get the guy to plead. Just get him off your. You're already overloaded. You're stressed out. You've got way too much to do. There are way too many poor people being prosecuted by the fellowship of the finger, Pinkston and the cops. We just need to go ahead and get this guy out. And very few cases deserve special attention, right? Very few cases that run through this mill deserve your vigorous defense for justice. You just have to say, well, and I'm thinking of one encounter I had with a man who's in the Judge Bales case. Judge Bales accused a black man for begging and harassing him, and I sought to find the reason why this man was being prosecuted and charged, and as it turns out, he pleaded guilty to the least likely of the charges. The least likely, the one, in fact, the statutory language of which didn't even apply to the fact. Not even the facts in the report didn't even apply. And yet this man pleaded guilty to that one. So even though this man was a lousy person in a lot of ways, he had a terrible character, and the police officer who endured a great deal of abuse, taking him in to be booked. Remarkable restraint of the police officer. Read the story at Nooganomics.com. He pleaded guilty to a charge that was the most remote and the most imaginative of all those stacked against him. Well, this is David Tulis, and we are looking at this prospect of reform in Chattanooga. We have considered this week the idea of a mental health court. And ahead, they're sought by the lady who's Anna Pratana Biggs, who runs the mental health court. There's the idea of having one for veterans, right? Veterans who are caught up in the whirring, grinding jaws of justice, as it's called, finding a way that they don't have to be ground into pieces and become charges of the state through the jail administration. These reforms are vital and they are important. And Judge Poole and Judge in Sessions Court Judge Lyle Statham are right to be commended for this effort, and they're very excited about diverting defendants from the court system here in Hamilton County. But what about reform on the front end? Now that's what I'm talking about, and I did have occasion to ask yesterday about that, and that would be simply enforcing of the law, simply a recognition that there cannot be any criminal case decided apart from intent. And you think, well, wait a minute, how have I not heard about this? Well, it's in the law, and it's part of American jurisprudence. It's part of the Christian godly elements in the law that are still there, right? The law is arbitrary and capricious. We live in a state of executive government and judicial anarchy, right? We have judicial anarchy today, thanks to the lawyers, thanks to queers, thanks to many other people who have brought cases that overturn the law, and of course, thanks to statutes which overturn marriage and overturn statutory marriage, and even marriage as God ordained it, which would be a common law. Even those marriages threatened by judicial anarchism. But here we are looking at a front end reform, and I'm trying to suggest to you that if we have a reform on the point of intent, where no charge will be allowed to be presented to me, right, Don Poole, or to me, Tom Greenhalgh, or to me, Barry Steelman, the criminal court judges in the county. No charge will come to me unless you, the prosecutor, aver that you have read the statute today and that you intend to prosecute this case and prove the requirement of culpable mental state. And I want to say, since you hadn't really heard much about this today on Cash Friday, we are on Cash Friday. I want to hold your attention. I've got some important messages to give to you, and I want you to pay strict attention. We are on Nooganomics Radio, 92.7 and 95.3 HD4. HD4 again is digital radio. We are the real 95.3 again, but it's over on the HD side, the digital side, on your new car radio system. There, you just find it. If you don't know how to find it, check your manual, or ask your teenage son. He already knows about these fine points. And there we are. David Tulis here. I cover local economy and free market. What is culpable mental state, and why does the state have to prove it? Because the state doesn't have to prove it, and the judges don't demand it, we have an overwhelmed judiciary. We have loaded dockets, and we have an abuse of the common people. And I'd say not just the common people, but even ordinary people like you and me, right? Middle class people, probably Caucasian, probably conservative people like us. Even we are ground to powder in this machine, but not as badly as the ignorant, not as badly as the poor, not as badly as those who just simply, they have no idea why they're there on failure to appear. Jennifer Nicole Mitchell, for example, homeless Chattanooga, age 32 years old, failure to appear. Well, I wonder why she had failure to appear. Will Neal Pinkston argue that she did it intentionally? She intended to violate the statute. Well, listen, some of these offenses are like not having something or not being somewhere. These are not intentional. Almost always, the people who are accused of these crimes are ones who just, they are constantly confounded by the contingencies of their lives, difficult lives that they lead. Where is the sense of grace and mercy upon them? I think it's impossible to have that if you're in that system. But you, my listener, you today on Cash Friday today, you should, and we will think about this in just a minute. But first, I've got some important messages. Cash Friday is where you and I go to our lender and get $100 out of the account. I'm holding here in front of YouTube and in front of Facebook 5 $20 bills, and with Hamilton, Andy Jackson. And why are we doing this today? Why Cash Friday? David Tulis.
The Tennessee Valley's news talk leader, Nooganomics Radio, digital FM 95.